Good evening, everyone. We'll begin shortly, but just want to provide you a quick announcement. For those that would like ASL services, we have two ASL interpreters on today, Andrea Alefai and Craig Ridgway. In the chat, we will share how to pin videos, and they'll be alternating every 20 minutes. Thank you again for joining us.
Thank you, Yahira, and good evening, everyone. Welcome to the January meeting of the Civilian Complaint Review Board. I want to thank you all for joining this discussion tonight about policing and civilian oversight. I'm Fred Davey, I'm the chair of the board, and before we get started, I'd like to ask my colleagues on the board to introduce themselves. Let me see if I can do this by, I'm going to try it by our list here. Mr. Joseph. Did we lose Mr. Joseph? He's there. Looks like he may be having a technical issue. All right. Mr. Rivadeneira.
Good evening, everyone. My name is Michael Rivadeneira. I am the City Council Bronx designee to the board. I just want to wish everyone a happy new year.
You're Mr. Puma.
Good evening, everyone. My name is Joseph Puma. I'm the City Council designee to the board from the Borough of Manhattan. And Happy New Year to all.
Mr. Dwyer.
Good evening also. My name is Frank Dwyer, and I am a police commissioner designee. Thank you.
Mr. Freeman. Mr. Freeman, I think you're on mute.
Hey, I'm Willie Freeman. You got me?
Yes.
Okay, well, please, Commissioner designee.
Great. Thank you. Ms. Irish.
Hi, everyone. Corrine Irish. I live in Harlem, and I'm a mayoral appointee.
Ms. Bond.
Good evening, all. I'm Erica Bond. I'm a mayoral appointee as well.
Ms. Pinsky.
Hi, everyone. Happy New Year. Angela Pinsky. I'm a mayoral designee, formerly from Brooklyn, now living in Manhattan.
Mr. Siegel.
Good evening, John Siegel, mayoral designee on the board. Nice to see all the board members and glad to be here tonight.
Mr. Joseph, we'll go back to you.
Good evening, everyone. Sorry for that disconnect. My name is Nathan Joseph. I am a city council appointee, and I live in Staten Island.
And I think Mr. Kakatera is on the phone.
Yes, hi, Fred. Good evening, everyone. I'm Sal Carcatera, and I am a police commissioner designee on the board.
Great. Excellent. Did I get everybody? Excellent. Thank you all. What happened last week and what our nation witnessed was nothing short of a racist insurrection in our nation's capital. Insurrectionists armed with guns and pipes planted bombs at both the Democratic and Republican National Committee buildings on the grounds of the Capitol. They desecrated the halls of a building that we all have ownership of and all should respect. It's also difficult to ignore the disparities in the way in which these white insurrectionists were treated versus the way black and brown individuals who peacefully protested police brutality were treated this summer in DC, in New York, and elsewhere. We can't lose sight of how we got here. When politicians and elected officials lie to their constituents, to the people they serve, they are doing a grave disservice and putting them at risk. People died needlessly last week because they were fed lies, because they were egged on to storm the Capitol to fight for these lies. We may have our disagreements, but there are never two versions of the truth. It may take us time, debate, and work to uncover it. And in the end, many may not like it, but pursuit of and respect for the truth is essential to a healthy democracy. Regardless of whether the topic is our elections or bail reform or the repeal of 50A or the fact that the mistreatment of Black and brown communities is still pervasive in policing across the country. As my friend and colleague, the Reverend and now Senator-elect Raphael Warnock said to his congregation this past Sunday, there is no transformation without truth. New York City has gone through a lot of pain and sickness and grief over the past year. This upheaval has uncovered many truths. One such truth is that accountability for NYPD officers who commit substantiated misconduct is often meager and inconsistent. Another is the many difficulties CCRB faces when conducting our investigations. And a third is that the relationship between the community and the police is not what it should be. We certainly confront these truths every day during CCRB operations and every month at our board meetings. But what went on last summer made adamantly clear that we are long overdue for the city and the state to confront truths and then to transform. The repeal of 50A, which this board called for in March of last year, was a start. So was the first Department Appeals Court authorizing CCRB to investigate complaints from people who view incidents in the news or online. What brings us here tonight, proposed rules to restart sexual misconduct investigations and empower CCRB to investigate false official statements by officers against civilians, is also a start towards a better future for oversight. But there is more work to be done, and the CCRB is committed to this work. In my testimony in front of the City Council on Monday, I made clear what the CCRB believes must be done to strengthen oversight and improve community police relations. Our agency needs direct access to body-worn camera footage. We should examine the final disciplinary authority held by the police commissioner, including the removal of final disciplinary authority for CCRB adjudicated cases. NYPD interactions with vulnerable members of the public, including those exercising their First Amendment rights, youth, and individuals experiencing mental health crises, must be de-escalated, and civilians should never face retaliation for filing complaints. These recommendations and others were made by our partners in government at the OIG of the NYPD and the Commission to Combat Police Corruption. And our Youth Advisory Council which also informed the policing reform plan. They serve as markers where the work begins, not where it ends. And if the city can commit to addressing the events of last summer and engaging with substance on the issues of police accountability and civilian oversight, then there is still reason to hope for the future. In addition to this discussion tonight and the recommendations we provided the City Council, in 2 weeks the CCRB will also be having a public discussion on the NYPD's disciplinary matrix. This matrix would be a major step forward in moving toward a system of police conduct that imposes consistent and fair penalties upon all members of the NYPD who commit misconduct. I want to be transparent about whether and how the board will use the matrix, and this meeting in 2 weeks will ensure that. I look forward to the CCRB staff setting up that future meeting, and I know and appreciate all of your participation in that discussion in 2 weeks' time. Finally, I want to thank you all for attending this meeting tonight, New York's essential workers for keeping the faith during such a difficult time, and the CCRB staff for continuing to do this difficult work as we move forward toward recovery. With that, I want to turn the floor over to our Executive Director, John Darsh, who will have a few words for us tonight, and then we'll proceed with our public conversation. John.
Thank you, Mr. Chair. Good evening, everyone. Thank you for attending here tonight. It is important that the public is involved in the rulemaking and policy creation with respect to policing and civilian oversight in New York City. Tonight is one such opportunity for public input. In February 2018, the CCRB passed a resolution to allow the agency to investigate sexual misconduct. Between February 2018 and May 2020, the CCRB investigated allegations of non-criminal sexual harassment, such as verbal harassment. We built competency, hired staff, investigations in the APU to investigate what we termed phase 2 conduct, such as physical assault and other potentially criminal sexual misconduct. We have not yet started to investigate those cases. The Police Benevolent Association sued the CCRB to prevent the agency from investigating sexual misconduct, but our investigations continued until the first department ruled that the CCRB had to use a rulemaking process and receive public input in order to begin investigating sexual misconduct cases. We are here tonight to hear from you, and we are excited to receive your input on whether or not the CCRB should be able to once again investigate sexual misconduct. We are also looking forward to receiving your comment on the second piece of the proposed rule change. In November 2019, New York City voted to empower the CCRB to investigate material false official statements made by subject officers during the course of our investigations. But this charter change only addressed a specific category of false official statements, which are not currently within our jurisdiction. In this proposed rule change, we are explicitly interpreting our abuse of authority jurisdiction to include another category of false official statements, those made by officers against civilians in official testimony or on official documents. If these rules are adopted, these types of false statements will be investigated as an abuse of authority. Following this meeting tonight and over the next few weeks, the board will consider the public feedback and will eventually vote on whether to adopt the new rules. This is an important night for civilian oversight of the NYPD. We look forward to hearing from all of you. Some ground rules for tonight. Please use the raise the hand feature to make a comment. The comment is going to be reserved. It's going to be limited to 2 minutes. If you would like to discuss a problematic encounter that you had with a police officer, please give us your contact information so that one of our investigators can follow up with you. I want to thank the staff for all their hard work in continuing our operations in these difficult conditions, and thanks again to the members of the public for participating.
Thank you, Executive Director Darsh. Before we go to the report from the Assistant General Counsel, I think we probably should approve the minutes from the last meeting. So is there a motion to approve the minutes?
So moved.
Motion.
Okay, it's been moved and seconded. Are there any additions or revisions to the minutes? Hearing none, all those in favor of accepting the minutes as presented, please say aye.
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 Any opposed? The motion carries. The minutes are passed. So now we will hear from our Assistant General Counsel, Heather Cook. Heather.
Hi, good evening, everyone. I am just going to run through a very, very quick PowerPoint on the rulemaking process. I'm just going to share my screen really quick. Okay, you all see that? Okay, so this is going to be a very brief run through just of our rulemaking process. So the legal authority for rulemaking comes from what we refer to as CAPA, which is the City Administrative Procedure Act found in New York City Charter, Chapter 45. As John said, based on the Charter Commission vote back in 2019, as well as the May 2020 First Department Appellate Court decision, the agency had to draft new rules to remain in compliance. We submitted the draft of those rules to the board, and then we sent them to the Law Department and City Hall for certification. The Law Department reviewed them for legal sufficiency. City Hall reviews them and make sure everything is compliant. Those certifications, as well as the draft of the new rules, were then published in the city records and on NYC rules 30 days prior to this hearing. We actually went a little bit more than 30 days this time, but it has to be at least 30 days prior to this hearing. At the same time, we also distributed this to other interested parties pursuant to Local Law 46, and these included the City Council, media outlets, and other interested parties such as unions and other organizations affected by these rules. Now that brings us to tonight, where we're going to receive public comment. The board will then, as John mentioned, deliberate, and at a certain point will adopt a final set of rules, taking into consideration everything that they hear from the public. After that, the Law Department will once again make a final review of our rules, again to ensure that they are legally sufficient. Once the Law Department signs off, we will publish the final rules in the city record one more time, and 30 days after that publication, our new rules will go into effect. So that is your rulemaking in under 2 minutes.
Thanks so much, Heather. Any questions for Heather from the board members? Anyone? All right, thank you, Heather. So we will now enter the public comment of the meeting. Again, if you are interested in making a public comment, please use the raise your hand feature, and we'll go down the list. Please keep your comments to 2 minutes. Yahira, would you please call on the first person?
Thank you, Chair. As a reminder, please limit your remarks to 2 minutes. First, we'll be hearing from Quadira Coles from Girls for Gender Equity.
Can you all hear me?
Yes, please.
Okay. Good evening, members and staff of the CCRB. My name is Quadira Coles, and I am the Policy Manager at Girls for Gender Equity. GGE wrote to the CCRB in strong support for interpreting jurisdiction to include sexual misconduct by members of the NYPD. Now, with the opportunity to give verbal comments, GGE would like to highlight some important recommendations to strengthen and clarify language use. GGE works daily with young women and girls of color who are policed at every juncture of their lives. In 2018, BuzzFeed released thousands of records of misconduct cases, and we found anecdotes involving school safety agents behaving inappropriately in numerous forms of sexual misconduct with students. Specific behaviors are listed in our written testimony. Researchers agree that while the issue of sexual misconduct is often invisible in public discourse around police violence, it is both prevalent and systemic. It is with this context and organizational experience that we offer these recommendations. In the definition of abuse of authority, we recommend the word sexual misconduct be expanded to include sexual harassment and sexual assault. Within the revised definition of sexual misconduct, we recommend adding sexual intimidation, coercion, and extortion. We ask that using physical gestures be expanded to include expressions. In addition to that, include language that encompasses a spectrum of digital and written forms of harassment, and also add in the course of duty or other than legitimate purposes with verbal sexual harassment to be inclusive of text-based communication or otherwise. Revise inappropriate touching to groping, as inappropriate is far too subjective a word choice. We would like the CCRB to explain on-duty sexual activity to indicate more of a spectrum of coercive sexual contact, in addition to including the use of a official position, identification card, or badge, or any use of department property or vehicles to coerce, persuade, force, or initiate, engage in sexual contact with anyone or solicit sexual conduct while off duty. We ask the CCRB to clarify on the decision to utilize of a sexual nature in comparison to discrimination or harassment that is gender-based. Our concern is that the scope then becomes too narrow or limited to deferring to sexual desire, neglecting instances of sexual violence arising from gender discrimination. A potential reframing might be misconduct of a sexual nature or motivated in whole or in part by a civilian's actual perceived gender or gender presentation. Delete the word gratuitously as shames or degrades does not need a qualifier. Replace the word sexual organs with body in part or whole physical attributes, attire, appearance, or gender expression. The language sexual organs is far too limited to physiology at the expense of ignoring a person's presentation or appearance. Lastly, include instances where an officer uses or refers to their own body as a form of sexual humiliation. Thank you for the opportunity to testify.
Thank you, Speaker. You hire our next speaker, please.
Thank you, Quadira. Next, we'll be hearing from Deputy Public Advocate Nick Smith.
Thank you. Thank you very much. Can you all hear me?
Yes, we can, Nick.
Great. Good evening, everybody. Nick Smith, First Deputy Public Advocate, on behalf of PA Jamani Williams. Before I quickly read the remarks, I just want to kind of frame, I think, where we are and how we got here. It's clear to me that the PBA, in suing the board when it did, the clear intent was to not just stop the adoption of these rules, but to literally keep these allegations secret. That's quite frankly unacceptable and just has to be called out. We can't allow these allegations against officers to be secret. That's just not acceptable. So to the remarks very briefly. So once again, I'm Nick Smith, First Deputy PA. We thank the board for having this hearing. No authority figure, especially a police officer, should abuse power. No survivor should be ignored. All rape and sexual assault cases must be investigated if an officer is the perpetrator. Survivors who experience severe and long-lasting trauma must be shown that no person is above the law. Therefore, I support the CCRB in leading sexual misconduct cases to ensure accountability. Without that accountability, there's no justice. In 2017, 2 officers sexually assaulted a young woman. This horrific, traumatic, and violent act has a name. It's called rape. The case even led to a new law a year later that prohibited sex between an officer and a person in custody. Unfortunately, the young woman did not receive justice, as in 2019, a judge gave a light sentence to these officers who later resigned. Worse, the credibility of the woman was questioned. Make no mistake, this is a justice system failure, and I see the time is running out. Very briefly as I wrap. Untruthful statements are also alarming and require investigation. Lying is so common among officers that prosecutors across the city, that is DAs, have a list of officers considered to be dishonest. Notably, Staten Island and Brooklyn DAs prohibit said officers from testifying. They must commit to the truth at all times. Finally, to wrap, I emphasize that there needs to be a reimagining of policing, and that first starts with accountability. Having the CCRB lead that process is a very helpful start. And our hearts and prayers are with any person who has been a victim of sexual assault and abuse, or have had to suffer from false statements made by an officer, particularly during a CCRB investigation. Thank you all, and we urge an aye vote on the resolution. Thank you so much.
Thank you, Mr. Deputy, First Deputy Public Advocate. And I would just want to say to board members, if you have any questions at all during the pause, please feel free to ask them. Thank you again, Nick. Yahira, our next speaker, please.
Next, we'll be hearing from Isabel Chandler, Community and Policy Aide for Councilmember Carlina Rivera.
Good evening. Can you hear me?
Yes, we can. Please proceed.
Okay, thank you so much. I'm unable to turn on my video, but I will be sharing a testimony tonight on behalf of Councilmember Carlina Rivera, and her full testimony is available on her social media. On behalf of my constituents of New York City's 2nd Council District, I respectfully submit these comments in support of the proposed CCRB rule change to include police sexual misconduct under its purview. Until 2018, New York state law did not explicitly forbid sexual contact between police officers and people in their custody. In 2021, there's no question that police sexual misconduct is a glaring abuse of NYPD authority and that the CCRB should be able to investigate it. I welcome this rule change as an opportunity to now codify an authority that should frankly already exist. Black and brown New Yorkers have historically been disproportionately targeted, harassed, and surveilled by the NYPD. Over the past year, our city has faced repeated instances of police misconduct, particularly during the Black Lives Matter protests. Under the umbrella of police misconduct, police sexual misconduct is especially egregious and inextricably tied to the movement to decriminalize sex work in our city. Decriminalizing sex work would eradicate incentives for officers to falsely arrest people for allegedly soliciting sex. This would also prevent so much of the violence that occurs when undercover vice squad officers fail to wear their cameras or badges while falsely arresting New Yorkers. In addition to oversight of police sexual misconduct, the CCRB should be the sole authority in recommending action, including firings for police officers found guilty of misconduct. And I stand in full support of this proposed rule change and will continue to advocate for bolder action and broader CCRB oversight. Thank you.
Thank you. Our next speaker, please.
Next, we'll be hearing from Zamir Bendan, staff attorney with Legal Aid Society, followed by Josie Torelli and Alvin Bragg.
Can everybody hear me, Stephen?
Yes, we can. We can't see you, but we can hear you.
Okay.
Now we can see you. Yeah.
You can see me now?
Yes, indeed.
Okay.
Let's go ahead.
All right. So, good evening. My name is Zamir Bendan, and I am a staff attorney with the Legal Aid Society. I am also a representative of the Black Attorneys of Legal Aid Caucus, which is an amalgamation of over 100 Black legal aid lawyers. Our written testimony and our comments today are focused on the issue of untruthful statements by NYPD. On June 26, 2020, our caucus sponsored a social media action drawing attention to the decades-old problem of police perjury, known as Testaline. Using the hashtag #CopsLie, attorneys from all over the country provided dozens upon dozens of real-life examples of police dishonesty. This action revealed what our caucus, what defense attorneys throughout the country, and what even prosecutors and judges all know, that cops lie, and they lie frequently. Testa lying is not new. NYPD cops have been lying for decades. What has been different over the past 5 to 10 years is the increase of cameras, both among business establishments and among civilians recording incidents with their cell phones. Now, members of the public are increasingly aware of how pervasive police perjury is. Whether it's to get around constitutional constraints regarding search and seizure, to cover up their own misdeeds, or to make arrests and quotas, Testa lying is a major problem that undermines the integrity of the judicial system, makes a mockery of any notions of criminal justice, and destroys the lives of people in the community. Simply put, there can be no justice as long as police perjury continues to go unabated. Therefore, in our view, the Civilian Complaint Review Board should be fully empowered to investigate police perjury and open the eyes that prosecutors and judges willfully close to this sinful conduct. Thank you.
Thank you very much. Next speaker, please.
Thank you so much, Samir. Next, we'll be hearing from Josie Torelli.
Hi, everyone. Can you hear me?
Yes, please go
Okay,
ahead.
great. Thank you so much. My name's Josie Torelli. I'm a licensed clinical social worker. I've worked with interpersonal violence since 2004. My social work career has focused specifically on intervention and prevention of sexual, gender-based, intimate partner, and domestic violence. My goal is to ensure that all people have access to expert and compassionate care following trauma. I earned my BA from Syracuse University, my MSW from Columbia University, and I've completed postgraduate certification in advanced trauma treatment. My prior experience includes work with the New York City Alliance Against Sexual Assault, the Training Institute for Mental Health, Institute for Contemporary Psychotherapy, Aldao Counseling Services, New York Presbyterian Hospital, Safe Horizon, and Long Island College Hospital, and I currently work as a consultant, also an adjunct lecturer at Columbia University School of Social Work, and published material related to trauma-informed care for medical professionals. And of note, I'm a survivor of intimate partner and sexual violence, and I feel that this is important to include as this informs my professional work and viewpoint, and to make clear that we're not talking about others who have experienced interpersonal violence. So as a professional and as a survivor, I'm here to support the investigation of sexual misconduct allegations via the CCRB's abuse of authority jurisdiction. I've worked with thousands of survivors of sexual violence in my career, including work in emergency departments, and often an important part of their healing is included naming and reporting what happened. This act involves a great amount of trust in the systems that are supposed to support crime victims. It's quite literally turning your story over to a system and outcome of the disclosure, and too many times I've seen faith in that system disappear as the system fails. So the failures of the current system are emphasized when working with people who have experienced sexual violence via the NYPD. In my experience, survivors who opt to report sexual misconduct face additional barriers to justice. How do you report a crime when it was committed by a member of that system? And in my experience as an advocate, it's been increasingly and very difficult in order to work with the Internal Affairs Bureau of the NYPD who investigates these crimes currently. And I also wanted to say, as a person who worked with the CCRB in order to provide training and trauma-informed care, I'm highly confident that their investigators are well-trained and prepared in order to investigate these claims. Thank you.
Thank you very much. Our next speaker, please.
Thank you so much, Josie. Next, we'll be hearing from Alvin Bragg, co-director of the New York Law School's Racial Justice Project, followed by Sandra Park and Chris Dunn.
Yes, this is Alvin Bragg. Can you hear me?
We can, Alvin. Please proceed.
Thank you, Chair Davey and Executive Director Darsh for convening us. My name is Alvin Bragg, co-director of the Racial Justice Project at New York Law School. We've submitted written testimony, so I'm just going to pull out a few key points. The first is we've cited to law, New York State case law showing that abuse of authority certainly includes false statements by police officers, and indeed not just New York State law, but federal law as well. I previously served as a federal prosecutor and tried an FBI agent for lying. This is some of the most significant type of abuse of authority, not just within the definition. Secondly, this is sorely needed, not just a jurisdictional point. Thankful to the CCRB for its work concerning former Officer Pantaleo. The Racial Justice Project represents members of the Eric Garner family and other police accountability organizers in a lawsuit against Mayor de Blasio and the city. That case centrally involves lying by Officer D'Amico, which was found by a NYPD administrative law judge, and we are seeking details about that 6+ years after Mr. Garner's death. So this jurisdiction is not just something that is significantly needed in the abstract, it is significantly needed in a very pressing way. I know the police unions and others are resisting the jurisdiction. This is a matter of public safety. We need community trust in order for us to have actual public safety, and it's paramount. Briefly to the second piece on sexual abuse, we have cited law as well showing it's not just state law that it's well within abuse of authority jurisdiction, but also when I was at the Attorney General's office, we investigated a local police department for this type of very misconduct, and a federal judge upheld a consent decree. So this is conduct that is well within the CCRB's authority of abuse of authority, and the Racial Justice Project respectfully submits that these rules be adopted. Thank you.
Thank you. Thank you very much. Next speaker, please.
Thank you so much, Alvin. Next, we'll be hearing from Sandra Park, Senior Staff Attorney with American Civil Liberties Union in the Women's Rights Project. Sandra, we are having a little trouble hearing you. No, we can't hear you. Oh, there you are.
You can. Please proceed.
Okay. I'm hoping you can hear me.
we can. Please go ahead.
Okay, great. Good evening. My name is Sandra Park. I am a senior attorney with the Women's Rights Project, and I'm testifying tonight on behalf of both the National ACLU as well as NYCLU on the issue of sexual misconduct. Both organizations strongly support the proposal for CCRB to accept and investigate complaints of police sexual misconduct. As our written testimony outlines, and as many others have already spoken to, police sexual misconduct is a pervasive problem nationally and in the NYPD, and that's borne out by a number of reports and studies as well as high-profile headlines. We believe CCRB investigation of these complaints is a critical step towards promoting police accountability, reducing sexual misconduct, and the harms committed by those officers that engage in this misconduct. And it's all the more important for CCRB to have this role because NYPD has failed over many years to adequately investigate and respond and address sexual misconduct within its ranks. So for most New Yorkers, until CCRB stepped in, there was no point in filing reports or complaints because they'd be doing so with the very agency that has long condoned the misconduct. In our comments, as others have said, we believe that this jurisdiction is entirely appropriate. And indeed, any arguments that police sexual misconduct does not qualify as abuse of authority minimizes the deep harms of this misconduct and ignores how officers' positions within NYPD empower these types of violations of civil and human rights. I'll note that in our comments, we do have some recommendations for amendments, particularly around clarifying when sexual misconduct can be committed when an officer is both off and on duty. But I'll just sum up by thanking the CCRB for undertaking this issue and expressing our support for the regulation.
Thank you, Ms. Park. Our next speaker, please.
Thank you so much. Next, we'll be hearing from Chris Dunn from NYCU, followed by Jen Bine Wong.
Chris, are you there?
Good evening, Fred. Can you hear me now?
Yes, we can. Please go ahead.
Good evening, Fred. Good evening, other members of the board. John. Fred, I want to say at the outset, I particularly appreciate your opening comments. What happened last week was not only a political crisis, it was a policing crisis, a race crisis. And I think what happened last week has to be considered in light of what the board is trying to do this evening, which we fully support. As you know, we took the very unusual step of filing in support of a city agency when the PBA challenged the initial effort to bring sexual misconduct complaints into your jurisdiction. We similarly support your move tonight, and I want to specifically address the issue of false statements, a nice way of saying cops who lie. As we all understand, police officer false statements pose a profound threat to the integrity of policing, to the legitimacy of the criminal justice system, the public confidence in both. I fault the CCRB, in fact, for not having investigated complaints about false statements by police officers that took place in court and in paperwork. It has always been part of your jurisdiction. There can be no question about that. If there's anything that qualifies as an abuse of authority, it's a police officer who lies on paperwork, lies in court, the result of destroying the lives of civilians. Any suggestion by the PBA or anybody else that somehow that is not an abuse of authority that the CCRB could always have investigated defies common sense and any notion of English language. So we are pleased that you have taken this step on. We actually think it was probably unnecessary and is long overdue, but we fully support the rule as it would affect false statements. And if the PBA sues, as we know they will, we can rest assured that we, the NYCLU, will be there in support of the CCRB if it has to defend such a case. Thank you.
Thank you, Chris. Our next speaker, please, Shahira.
Thank you, Chris. Next, we'll be hearing from Jen Vine Wong from the Cops Accountability Project at Legal Aid Society, followed by followed by Marianne Kashian.
Hi, can you all hear me?
Yes, we can, Jen Vine.
Thank you. Good evening, and thank you to Executive Director Darsh, Chair Davey, and the board for the opportunity to testify about these long overdue and important rule changes proposed. My name is Jenvin Wong, and I'm an attorney with the COP Accountability Project at the Legal Aid Society. To be clear, police sexual misconduct and false statements are clearly abuses of authority by any plain understanding. These forms of misconduct are enabled by the authority of the officers that perpetrate them and cause devastating harm unto their victims. And first, in addressing the issue of police sexual misconduct, NYPD's persistent failure to properly investigate complaints of sexual misconduct is endemic of a toxic culture that does not take sexism or sexual violence seriously. Since 2018, Legal Aid's Exploitation Intervention Project, a project that represents people prosecuted for prostitution-related charges and advocates for survivors of sex trafficking and sexual exploitation, has demanded accountability for this systemic sexual harassment and assault of our clients by NYPD Vice Enforcement Division officers. And in a recent investigation by ProPublica, it was revealed that 17 women reported to their attorneys a sexual assault committed by a single undercover Vice officer. And NYPD leadership has shielded that officer from any meaningful discipline, despite compelling allegations of false arrest and sexual misconduct reported to the OIG almost 3 years ago. And internally, NYPD has woefully failed to curtail sexual harassment and assault against their own members. NYPD continuously fails survivors of sexual abuse, whether they're civilians or members of service themselves. And officers cannot continue to hide behind a cloak of authority while exploiting the vulnerable people they interact with. I invite the board to review my written testimony that discusses more in depth these underlying failures of NYPD. And at a minimum, survivors must be able to report police sexual misconduct to an agency other than the one that has perpetrated the harm. In turning to false statements, there is no other way to put it. As my colleagues so succinctly and eloquently testified earlier, cops lie. They make false statements in official documents, in conversation with prosecutors and on the witness stand and under oath. And those lies have life-changing consequences for legal aid clients and for their freedom. Yet, even in cases where an officer's false statements are exposed, it is rare that officers are held to account in any way whatsoever. Officers remain on the street to do it again and are even promoted through the ranks. NYPD has been unable to curtail the rampant lies that are told by members of service, and the district attorney's offices protect them. Police lying is so prevalent that it has earned the moniker of test-a-lying. In the last 12 years, the Manhattan DA's office has charged only 4 officers with perjury and 26 with charges related to lying about arrests or summons. Many attorneys in our criminal defense practice report that officers' own body-worn camera will often directly contradict...
Ms. Wong, we're trying to limit people to 2 minutes.
I understand, and I'm finishing up. And many attorneys in our criminal defense practice have reported that there's video that directly contradict police testimony and statements on a regular basis. And yet these officers evade accountability on a regular basis while our clients become ensnared in the criminal legal system based on these lies. The proposed rule changes would provide civilians an opportunity to seek accountability with an entity other than NYPD and NYPD itself, and we support these rule changes. Thank you for the time.
Thank you. Can you hire our next speaker, please?
Next, we'll be hearing from Marianne Kashian from Brooklyn Defender Services.
Thank you for having this hearing. My name is Marianne Kashian, and I'm Senior Policy Counsel with Brooklyn Defender Services. BDS supports the proposed rule changes, which are in accordance with the best interests of residents and the will of New York City voters. I'm going to address the sexual misconduct aspect of those rule changes, and we echo Girls for Gender Equity and other organizations' calls for clarifying definitions and the addition of expansive language. Sexual abuse and harassment is endemic to NYPD interactions with civilians. People of all genders and sexual orientations are at risk of abuse, but many of the individuals subjected to this common form of misconduct are targeted specifically because of their sexual orientation, race, and/or gender and gender expression. The police commonly subject women and sex workers of color to sexual abuse and harassment. This is a race and gender justice issue. The inherent power imbalance between civilians and the NYPD is heightened by the race and gender dynamics often present in abusive police interactions, and it is completely unreasonable to expect victims of sexual misconduct to turn to the police and the department for help. As public defenders, we represent people who are targeted with gendered slurs, unwanted advances by officers, many of whom are uniformed and on duty. Officers take pictures of people's bodies and faces with their cell phones and critique appearances, mocking people based on their gender expression. Members of the Vice Squad, including others, routinely abuse people in their custody and other targets of their rogue operations. Some officers, such as the undercover officer known as UC-157, commit rape, sexually humiliate people in custody, obtain sexually compromising information on people, and blackmail people into sex. Without an independent investigatory body to turn to, victims of sexual misconduct are left with no recourse other than reporting the incident to the NYPD itself, all but ensuring inaction while risking the NYPD's notorious retribution and additional harm. Members of the NYPD understand that the current system all but guarantees not only the unaccountability of the perpetrators, but the continued victimization of targeted people should they turn to their abusers for help. Like other forms of police abuse, sexual misconduct by officers is an exercise of unchecked police power over civilians that should be investigated by the CCRB as an independent agency. It is unacceptable that these complaints are excluded from CCRB jurisdiction, particularly given the sensitive nature of the allegations. And I see I'm out of time, I'm just finishing up. And the valid reasons that targeted people would decline to lodge these complaints with the NYPD. The current exclusion of sexual misconduct from the CCRB's investigatory power serves no purpose other than to provide cover for abusive police. The expansion of CCRB power should be accompanied by other mechanisms of reducing the scope and authority of the NYPD, and it must happen immediately for the safety and welfare of the city. Thank you.
Thank you. Next speaker, please.
Thank you so much. Next, we'll be hearing from Lori. Oh, sorry, she might have been lost. Sorry. Next, we'll be hearing from Rachel Geller.
Speaker, please go ahead.
Can you all hear me?
Yes, we can. Please proceed.
On behalf of the New York City Alliance Against Sexual Assault and the New York State Coalition Against Sexual Assault, I'm here to reiterate our comments submitted and express our support for changes to Chapter 18A, Section 440 of the New York City Charter, expanding the CCRB's authority to encompass police sexual misconduct. Sexual violence is an abuse of power, and far too many of our clients have had the unfortunate first-hand experience of abuse of power at the hands of the NYPD. Research bears out our anecdotal evidence. In 2015, a national survey found that on average, a police officer is reported for sexual misconduct at least every 5 days. In NYC, a 2003 survey of young adults found that 2 in 5 young women reported sexual harassment by law enforcement, and half of those victimized were young women of color. Without independent oversight, police perpetrators often evade accountability. Internal reporting systems that represent law enforcement value internal, political, and reputational protection and close cases above safeguarding the fundamental human rights of survivors. As a result of the current system's failure to protect survivors, many survivors do not report sexual misconduct by law enforcement. As the CCRB moves towards taking on the responsibility, we further recommend that the Council consider the following needs. Require training so investigators learn how to center the unique needs of survivors through an inclusive, anti-oppressive, and trauma-informed framework. Ensure that the reporting process is clear, conspicuous, and accessible. Formulate internal and external procedures to protect the privacy of survivors. Execute timely investigations with a thorough communication system. Ensure there is a mechanism for survivors to be connected to resources such as hospital services and mental health counseling if desired. Under Section 101, we suggest the removal of the word gratuitously from the definition in order to avoid making complainants reach an arbitrary standard of humiliation. Under Section 101 in Categories 17 and 18, we request that complainants be given the opportunity to rescind their agreement to move forward with mediation before, during, or after the process, since mediation may result in survivors feeling intimidated or coerced into an agreement. In conclusion, both of our organizations overwhelmingly support the expansion of the CCRB's authority, jurisdiction, composition, duties, and power to encompass sexual misconduct by police officers. Thank you.
Thank you. Next speaker, please, Yahira.
Thank you so much. Just to remind folks, if you would like to share any hand feature. Next, we'll be hearing from Lori Roberts, State Policy Advocate, followed by Kelly Grace Price.
Hi, everyone. Can you hear me?
Yes, we can. Please go ahead.
Great. Thank you. My name is Lori Roberts, and I'm a state policy advocate with the Innocence Project. Thanks so much for the opportunity to testify this evening. We're an organization that works to exonerate wrongfully convicted people across the country and here in New York City, where 19 people have been proven innocent through DNA testing since 1991. And the Innocence Project can draw a straight line in numerous cases from false statements made by NYPD officials to the wrongful convictions we spend our time overturning. So we strongly support this proposed rule change to ensure the CCRB can investigate matters of truthfulness because the consequences when officers lie are devastating. I really want to note specifically that when NYPD officers make false statements to bolster convictions against innocent people, the real perpetrators of those crimes remain undetected in the community. Indeed, the real perpetrator was identified in 50% of the 375 wrongful convictions proven by DNA nationwide. And those people went on to commit 154 additional violent crimes, including 83 rapes and 36 murders. So false statements made by NYPD officers is a public safety issue. My written testimony details a number of examples from our casework where wrongful convictions occurred because of false statements, but I just want to highlight Andre Hatchett's story. He spent 25 years in prison for a murder he did not commit, in part because of false statements by the NYPD. And when he was exonerated by the Conviction Review Unit of Kings County, they specifically noted, quote, "It was implausible to the point of saying impossible for Hatchett to have been able to commit all of these acts," and specifically noting the NYPD's problematic investigation. And when he was exonerated, he filed a lawsuit that won a $12 million settlement with the city. But he noted in that lawsuit, Mr. Hatchett seeks to bring the defendant's misconduct to light and to ensure they are held accountable for their actions. I see I'm out of time, so I'll just quickly finish up to say the one way to make sure the tragedy of wrongful convictions never happen again is to investigate these falsehoods when they happen. In all of these examples, victims only discovered these officers' lack of credibility after spending years behind bars. The courts emphasized the connection between untruthfulness and exoneration, and these officers rarely faced consequences for lying with impunity. So the Innocence Project strongly supports this rule change, and the CCRB must be fully empowered to investigate police officers who make false statements. Thank you so much for your time.
Thank you. Our next speaker, please.
Thank you so much, Lori. We'll be hearing from Kelly Grace Price, and that will conclude.
Speaker, go ahead, please. Is the speaker there? All right. Yahira, do we have written testimony from this speaker?
Kelly, are you able to unmute? We do not have written testimony from Kelly. But Kelly, I will send you my email in case you do want to provide that. If you're unable to mute or turn on video.
Excellent. Okay. So let me see if any of the board members have any questions before we proceed on anything that we have heard in the testimonies so far.
Mr. Chairman, John Siegel, I have a question. We received extensive written testimony. Many of the people who submitted that have appeared today. My question is whether the police unions that submitted testimony were invited to appear this evening to testify, and if so, what responses we got, because I've read the testimony and raises some issues I'd like to ask about, and begins with their statement that the CCRB has, in effect, carried out this rulemaking process in private And here we are in public session, and I just want to know whether they were invited and what response we got.
It's my understanding that they might actually be in attendance somewhere in our participants, but chose not to speak. Is that correct, Yahira?
Actually, Chair, from our understanding, we haven't seen anyone from the unions in attendance, but that's correct. Mr. Siegel, they did submit testimony and are invited to testify.
Actually, you said they are not in attendance. I thought you said they were. Okay.
I'd just like to know, for the record, I have some questions on points that were raised in that testimony, and I, for one, would appreciate an opportunity to engage in a dialogue with them.
Mr. Chair, if we did expect the representatives of the union to be in attendance today, but they were not. And Mr. Siegel, if you have questions, I'll talk to Mr. Gadushin and see if it's appropriate for us to take questions from you or any other board members and reach out to the union. We would certainly have to make those done in writing and publicly available, but it seems to me that's something we could do.
Thank you, John. John Darsh. Mr. Siegel, any other questions or comments on this?
No, I just wanted to note, I thought Mr. Bragg's testimony where he identified pre-existing case law that informs the definitions of untruthful testimony and sexual misconduct was particularly helpful. It seems to me that we're not writing these rules on a blank slate, and that incorporating pre-existing case law makes good sense, and I thought that was particularly helpful, and I just wanted to commend that contribution.
Great, thank you. Any other comments or questions from any of the other board members?
Yes, Mr. Chair, this is Frank DeWalt, in case you can't see me. I just want clarification on, I was up, as I suspect a few of us were, to about 3 o'clock this morning reading the testimony, and the testimony is phenomenally rich, and certainly one cannot easily take it all in. So recognizing the requirements of open meetings and other things, what is the process now of discernment in terms of taking the testimonies, going through our proposals? How will that be taken on? How will the board be involved before something is brought back to the public? I would think at a next meeting or a third meeting for us to vote on, etc.
John, do you or Matt want to talk about this? My understanding is that we're going to try to have this, be ready to vote on this in at the February board meeting. If we need to have another public conversation before we get to February, I'm sure we can schedule that. But John, do you want to talk about the process as it now stands?
So my understanding is that at the February board meeting, if there are motions to change the language of the proposed rules, we'll then have to vote on that. And if the language changes, we'll go to the general counsel who make a determination. If it's a substantive change, then we're going to have to restart the process. And so that would mean that we would have to go back to the Mayor's Office of Operations and the Law Department to get approval for the new language, and then have another public hearing, and then potentially vote. So it's fairly straightforward, although long.
Hi, it's Kelly Grace Price. I just wanted to say I was able to unmute my button if you would like to hear from me.
Sure, Ms. Price, go ahead.
I'm about the technical difficulties. Not a fan of this WebEx platform. I wanted to say that I've read and listened to the other advocates that have submitted testimony, and I agree especially with the considerations that the Alliance submitted. I have much respect for that organization, having worked with Mary Haviland on the Downstate Coalition. And with that in mind, I just wanted to say there's nothing in the rules that allots for the backside services to people that make complaints. The CCRB is only obligated to send a letter via U.S. Postal Service at the end of its investigation notifying the complainant of the status of their complaint, whether it's founded, substantiated, or unsubstantiated. And survivors deserve more than just a letter. What's the plan to manage the flow of information to survivors post-interview? And survivors aren't notified when administrative trials are held if their complaints are founded. And we're not able to participate in that. We're not able to submit victim impact statements. There's no information about the agreements between the Borough District Attorney's Office's investigations into criminal acts by alleged criminal acts, sexual acts by police officers, and how those investigations will dovetail, stall, or coincide with CCRB investigations. We need more information about how, what the service level agreements between these two organizations are. We don't know if investigations will be stalled pending the outcome of CCRB investigations. We don't know. And we also don't have any previous data on how many investigations IAB or Department of Investigations, OIG, has done over the past 10 years. I submitted in my written testimony, I heard someone say that they hadn't received my written testimony, so I'm very happy to send it again because I spent an enormous amount of time looking for data about previous investigations into NYPD sexual abuse, assault, and harassment against citizenry and against other NYPD staff members. And I was able to parse out some data that I presented to you. We'd like to know, if this data is accurate, and does the CCRB have previous data into this kind of allegation that we can look at? Please, I know I've taken my 2 minutes. Thank you so much for listening to me, and please pay attention to my written testimony. I'm happy to send it again.
Thank you. And Yahira, if you could talk to the speaker about getting her information and getting testimony.
We'll follow up.
Thanks so much. Any other comments from board members or staff? Questions?
Esmeralda Simmons, I'm sorry for being late. I was stuck at a doctor's office trying to get a COVID test.
There you go.
All day long. It's an occupation, folks. Anyway, I refused to leave when he finally called me, even though it was right at the same time as our meeting. I, too, searched the documents to get a real good idea of how many complaints occur per year, and I'm not satisfied that I actually have a grasp on that, because obviously that will color how many cases, additional cases may come through. And I believe there might be actually more cases since it's going to be coming to us rather than to NYPD or AIB. So I too am interested if we have any data on the number of cases we're talking about.
Great, thank you. I do know that, John, in the past, we had collected data on the cases that we sent over to the IAB, I'm assuming over a given period of time. And if we could share that data again, and then any other data that might be relevant that for the board members.
So I'm trying to find it. I'm pretty sure we posted it on the website, but if we haven't, we'll get it up there soon. And if I can find it in the next 2 minutes, I will unmute, share that information.
Great, thank you.
That's great, but the real numbers will be closer to what complaints are sent to the NYPD as well on this topic. Thank you.
Correct. The referral numbers is what I'm going to try and get.
Yeah. Okay. Thank you.
Great. Thank you.
Everybody go get tested. All right.
Or vaccinated, assuming eligibility.
That's Saturday. I have an appointment for Saturday.
Great. Great. Other comments or questions for the staff, other board members?
This is Nathan. I have a question. I don't know what happened. I got bounced offline again. I guess my internet is not very stable. I had a question about, I think it was Genvine Wang had talked about sexual misconduct officers against other officers. Is that something that we could even look at, or is that totally outside of our scope?
John, you want?
In order for it to be in the CCRB's jurisdiction, it would have to be an on-duty police committing conduct against an off-duty police officer.
And we have had at least one. I've been on at least one of those cases since I've been on the board, not for sexual misconduct, but for another fatal issue.
Okay, thank you.
Sure. Other comments, questions?
Mr. Chair, this is Joseph Puma.
Sure, please.
So, yeah, John's answer kind of is a good jumping off point, I think, for my question. And I heard it come up in a few of the testimonies. And so, a point of information, most CCRB cases arise from incidents involving officers who are on duty. I know that we have also investigated and adjudicated cases involving officers that were off duty. So I just wanted to provide, ask that question to the staff in terms of when, what our jurisdiction is and what our role is, depending on whether an officer, a complaint is involving an officer on duty or off duty. Since it occurs to me that this particular universe of sexual misconduct allegations kind of lends itself to, maybe more variance in terms of whether an officer is on duty or off duty, or pattern of harassment involving an individual might involve times in the chronology when an officer was on duty or off duty. So I just wanted to ask that question so that the public is clear.
So that if an officer is off duty but invokes their authority as a police officer. So if for example, if an officer is off duty but uses their shield to pull someone over while they're driving, then they would be considered on duty. If I may go back to Ms. Simmons' comment, I got the numbers on referrals to IAB for sexual misconduct. In 2016, there were 50. In 2017, there were 61. In 2018, there were 58. In 2019, there were 18. In 2020, there were 31. That is just referrals. We did not investigate those matters, so I don't know the results of those investigations by the Internal Affairs Division.
All right, thanks, John. First, Mr. Puma, did you have any other questions for John or staff?
So no, the answer was what I understood. So an officer who would be off duty has to invoke their police authority in the incident, and that sort of would be the subject of a CCRB investigation, right?
Correct.
Yeah.
Okay. Thank you.
Sure, thank you. Ms. Simmons, you heard John's statistics. Do you have any other questions or comments?
Oh, I thought I had unmuted myself, and thank you. Thank you, John. That was it. Thank you.
Thanks a lot. Anything else on these questions for board or staff?
Yeah, so I had a question just to clarify with regards to false statements by officers. Would that include statements by officers that are false during the course of our investigation? Would we
So-
have jurisdiction over that?
So we have jurisdiction over that already due to the charter. But the charter language specifically referred to, can someone just give me a thumbs up if they can hear me because I'm getting weird things on my screen.
Yeah, we can hear you. Go ahead, John.
The charter revision specifically applied to false statements made to CCRB. Because of the timing of the CCRB investigation, the civilian might not know they were made, can't file a complaint about them. So it gives us the authority to investigate them separate from abuse of authority.
Does that answer your question, Ms. Iris?
Yes, thank you.
Sure. Okay. Any other questions? Comments on this? All right. Any old business to come before the board? Any new business to come before the board? Hearing none, is there a motion to adjourn to executive session?
Moved.
Second?
Second.
Second.
Those in favor of adjourning to executive session, please say aye.
Aye.
Any opposed? Motion carries, and we are adjourned to executive session. Thanks to the public and thanks to all of you.